SJC-12340, Commonwealth v. Jorge Ramirez.
Mr. Keene, good morning.
May it please the Court, Benjamin Keene on behalf of George Ramirez. Section 131J of Chapter 140, which outlaws entirely the private possession of stun guns and tasers, is clearly in violation of the Second Amendment, and this Court should so declare. The statute makes no exceptions for private persons and criminalizes the possession of a weapon that was created for the specific purpose of providing non-lethal self-defense in case of confrontation, which is the core purpose, Heller tells us, of the Second Amendment. So in this Court's Caetano opinion, the Court affirmed Jamie Caetano's conviction for possession of a stun gun and rejected the contention that the statute was unconstitutional, primarily on the grounds that stun guns did not exist in 1789.
Can I just want to ask a question about, I know you're going to get to the dangerous and unusual, right? So does a weapon have to be lethal in order to be dangerous?
Does a weapon have to be lethal in order to be dangerous?
Because I thought your argument was that, well, stun gun's not lethal, you know, there's no permanent harm, but isn't that the case with waterboarding? I mean, you know,
So waterboarding is not an arm, it's a form of torture.
But my point is...
Right, I don't think it does necessarily need to be lethal, but I think the term from Heller, which says that the Second Amendment does not extend to the historical tradition of prohibiting dangerous and unusual weapons, which is what you're asking about, has to be read, first of all, as a conjunctive test. It's dangerous and unusual. And although Heller does not define that phrase, it does give examples of types of weapons that are not covered by the Second Amendment for that reason, because they are dangerous and unusual. For example,
Gives one example, right? Sawed-off shotguns.
Sawed-off shotguns, machine guns, and the other reference in Heller is to M16s and the like. And now they're not specifically saying in Heller that those are dangerous, unusual. They're saying, but it's in the same passage, and it seems to me what Heller means by dangerous and unusual is a term of art that refers to whether a weapon is reasonably and typically used for by law-abiding persons for lawful self-defense. So that is why the waterboarding example, if you could shoehorn that into a bearable arm, you don't waterboard in order to defend yourself.
What about a BB gun? That's dangerous, isn't it?
A BB gun, so in Caetano, the Court equated the dangerous piece of the dangerous and unusual test from Heller with dangerous per se at common law. And dangerous per se at common law includes any weapon that is designed to kill or injure. For example, a firearm, which we know Heller has enshrined as the arm that is accorded special Second Amendment protection. So dangerousness per se, dangerousness itself clearly can't be enough. It has to be especially dangerous and unusual. In the Davis case, Justice Kaplan describes why shotguns, sawed-off shotguns, I think the adjective he uses is especially dangerous, is because they are designed to be easily hidden and because their shot scatters indiscriminately. So you can see why that would not be a weapon that a reasonable person would typically carry for purposes of self-defense in case of confrontation. The same is true with a machine gun.
Doesn't the U.S. Supreme Court use the word unusual and they focus on it numerically, just how many of the weapons exist out there, right?
Well, the Supreme Court talks about handguns being the most popular weapon in the country. And the Commonwealth refers to federal cases post-Heller that use that language to try to make a sort of a counting game out of this issue.
So you think the U.S. Supreme Court used that terminology just to prove the negative, that handguns were not unusual because they were so prevalent and they weren't focused on the number of the guns out there?
I think that's fair to say. I think they were focused more on the fact that many Americans who are law-abiding and want to lawfully defend themselves with a weapon have chosen the handgun to do so.
Before you go too far down the dangerous and unusual argument, if we could take a step back, because Heller and McDonald versus the city of Chicago, it's really talking about self-defense in the home. And my question has to do with, considering that that's what Heller's doing and McDonald is doing, what is the level of scrutiny that we're dealing with when you're dealing with a weapon outside the home?
So Heller, in my view, Heller answers the level of scrutiny question because just like the laws and regulations at issue in Heller, 131J bans an entire class of Second Amendment arms, and therefore, according to Heller, cannot withstand anything greater than rational basis scrutiny. So
But they do that in the context of the home.
well, yes and no. The statute at issue in Heller, like the statute here, is a total ban, meaning that it prevents a person from carrying the arm anywhere. And Heller emphasizes, for reasons we can divine, that the home is the sort of most sacred place where the need for self-defense is most acute. But the statute itself at issue there made it impossible to bear firearms in or outside of the home. Same is true here, which is why the in the home as applied analysis is a rabbit hole, in my opinion. The statute here
Is a radical?
rabbit hole, a
Rabbit hole.
rabbit, like a little.
I know what a rabbit hole is, I just...
Well, I don't know, but I don't know. I mean, it seems to me that those cases are talking about sacred right of self-defense in hearth and home. And
That's exactly the phrase that Heller uses, hearth and home.
And so I wonder if you're outside the home, of course, there can be regulation, but the question's going to be, is the scrutiny the same?
So, for the reason I just said, I think that it passes rational basis. Heller says any total ban that bans a Second Amendment arm in the home and outside of the home fails because this is a individual enumerated constitutional right, and some level of heightened scrutiny is appropriate. So the other piece of the question, and this is what the federal courts have debated post-Heller, is assuming that this does not fit into the Heller total ban of an entire class of arms. Is it constitutional because it withstands some heightened level of scrutiny? And as to that question,
But I'm confused. We're dealing with a total ban here.
we are. My threshold argument is you don't need to get to the question of what level of scrutiny applies or whether the Commonwealth can make a showing here because this is controlled by Heller.
Well, you say that, but Heller reads, and I quote, from Blackstone through the 19th century cases, commentators and courts routinely explained that the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. The court identified a non-exhaustive list of prohibitions and restrictions on the Second Amendment right, including prohibitions on carrying concealed weapons. So does that not say that we're not necessarily speaking about prohibitions on carrying concealed weapons? That may not be within the historical Second Amendment right?
I think that is accurate. We are,
but
a ban on carrying a concealed weapon, the Supreme Court has not spoken on whether that's.
So, but I mean, why can't we, if you are right, why, if the Supreme Court has not yet said there cannot be a ban on carrying concealed weapons, why do we not say we're going to save the constitutionality of this statute and say that the ban on stun guns is unconstitutional to the extent it bars the possession in the home? And that's in keeping with Heller, and we are not going to go beyond where the Supreme Court went in Heller and speak as to whether or not the right under the Second Amendment includes the right to carry a concealed weapon that is an arm under the Second Amendment.
Well, let me just step back one moment and say that I agree there are questions left unanswered by Heller. But this is not a difficult case. This statute is clearly overbroad. It clearly bans a valid weapon of self-defense. The job of this court, it seems to me, and which I respectfully say did not carry out in Caetano, is not to figure out how to get around Heller, but how to apply it. If the weapon is useful and reasonable by law-abiding persons in case of confrontation, then a statute which makes it criminalizes its possession, whether you are defending yourself in hearth and home, or like Jamie Caetano, if you're homeless, or anything in between, cannot survive any level of scrutiny.
You agree that a ban is impermissible, but regulation is permissible?
Sure.
And along those lines, if we were to conclude that you're correct and that this is an unconstitutional statute, would it be permissible, or would it be unconstitutional once that decision issued to give a delay to implementation so the legislature had some time to prepare reasonable regulations?
I would object to anyone like Mr. Ramirez being prosecuted under a statute that has been declared
I'm not
unconstitutional.
suggesting that he'd be prosecuted, but I'm just saying, well, I guess that's where it would go, wouldn't it?
So you're saying that we have no choice but to declare that this is unconstitutional,
On its face.
and that the right to bear arms includes the right to carry an arm outside the home?
I don't think you have to go that far.
I mean, how do we not go that far where your client was not found in possession of it in the home? He was found in a car.
Because this is not an as-applied challenge. I would refer the court to the Yana case, which is the only reported decision dealing with, prior to this court's Caetano opinion, that deals with a statute like this that bans electrical weapons altogether. It's an intermediate court of appeals decision from Michigan in 2012. It is in the same posture as this case, interlocutory review of a denial of motions to suppress. It is not cited in Caetano, and it is, and it should be. It should be. You should tell me why it doesn't control. And the defendant.
This is from a Michigan state court?
Let me
I can tell you
withdraw
why it
control.
doesn't control if it's from a Michigan state court.
It is persuasive, it is straightforward, it takes what Heller says and says that a statute that completely bans possession, whether it's concealed, whether it's open carry, whether it's home, whether it's in a, I think it's in a store with respect to one of the defendants in the Yana case, it doesn't matter. The same could be said about.
So if you're right, if we do what you say we should do, am I correct that the next day felons can purchase stun guns, children can purchase stun guns, persons convicted of domestic violence can purchase stun guns, and that there will be no law that will prohibit their carrying a stun gun?
Well, this goes to Justice Seifer's question, which I hadn't really thought about, whether there is a way of safely dealing with a transition period. And if you'd like, I'd be happy to think about it and submit something. But
Would it be possible, probably not, but would it be possible to just fold it into the framework of other regulations, other legislation that we have already on other kinds of firearms?
yes, and I think the Commonwealth brief points out there's at least one pending bill, and I don't know what the status of it is at the moment. So
But it's
ultimately, the solution.
it's not within the definition of a firearm, correct?
Right, they would need
So
a
you're
new.
asking us to basically say, although it's not a firearm, we are going to declare it a firearm, even though it does not meet the definition of a firearm, and we're going to impose the regulations that we impose upon firearms with regard to stun guns, even though they're not firearms. That's what we should do?
No, I don't think, I'm not
So, I
advocating
mean,
for
here's the
that.
problem. I mean, you're basically asking us to do something which you recognize to be a serious safety issue for the public. You're asking us to essentially say it is okay for felons, children, domestic violence perpetrators to purchase stun guns and carry them on the street. And if the legislature fails to act, that is the law which this court has declared pursuant to your argument. That
Well,
is
let me-
what you're saying.
I wouldn't put it that way.
Well,
but
I understand that, but isn't
but
that true?
I point out that every state but Massachusetts and 4 others permits stun guns, and I haven't done a state-by-state analysis to see what kind of restrictions, but Massachusetts is one of only 5 states that bans them altogether.
But you
If you do what
don't
we
know
said,
whether the
the legislature
45
would be working pretty quickly, I can guarantee, to address the issue, and I would encourage them to do so.
No knowledge about what the other 45 states do, though, as far as regulations go?
It's all over the place.
Okay.
Is my understanding. There's a law review article that is cited in the concurring opinion in Caetano, as well as in the brief, that is a little outdated. But Massachusetts, my understanding, is one of only 5 states that bans it altogether. There are some states that regulate the possession and use of stun guns to such an extent that there are very few of them. This is quintessentially a legislative decision, the regulation piece of it. But let me just go back to your concern
the
about
legislature has
safety.
made a decision. You're asking us to overturn it on constitutional grounds and saying
Well,
that
yes,
that
but I do have a little support.
The Constitution requires the result which you understandably are concerned about.
And then, the sky did not fall in Michigan after the Yana case was decided. Stun guns, it should be emphasized, are non-lethal weapons, and I'm not saying that they shouldn't be regulated. I'm just saying, that if you're worrying about
Doesn't the definition of stun guns say that they're defined as things which have the capacity to incapacitate or kill?
Well, then
That's their
they are not
definition in the
intended to
statute.
kill. No, they are not intended to kill. They kill very
I know they're
rarely.
not intended to kill. Guns may not be, but
But on the other side,
60
they're
doesn't
also one of the weapons used by women often in self-defense, right?
As
So
in
it-
Jamie
it's-
Caetano's case, and
It's
as
a
in the-
complicated inquiry
It is
about,
obviously a valid weapon of self-defense for someone who is responsibly using it, as was the case with Jamie Caetano and Brittany Rourke, whose case was dismissed following the Supreme Court's decision by a BMC judge.
Can I ask you a legal question back to the applied versus on its face. So you bring an on its face challenge. Our duty, right, is to avoid, unnecessarily broad constitutional decisions. So do we then interpret the statute to save it? I mean, I'm just trying to understand, in which cases should we turn to on that, or do we just do what you asked, which is declare the statute overly broad?
I think it's the latter. I
And
don't
in
think it can be
cases
saved.
that say that, you have law that supports that approach as opposed to the alternative?
Well, okay, so the Yana case again declares the Michigan statute.
Yana's a great intermediate appellate court, and I have high respect for the Michigan courts, but it's not in any way binding on us. So
Well,
how about our own case law on how we decide as applied versus on its face challenges?
So there's a case cited in the reply brief, which is, I don't know if this directly answers your question, that describes when, in the Second Amendment context, an as-applied versus a facial challenge governs, and that's the Holden case from 2015. But it doesn't really translate to here, because that's about regulations that deem whether someone is suitable or not to have a regulated arm. So this is not, and the Commonwealth cites the legal, it's actually honored more in the breach. It comes from the Salerno case that says, that a statute is, that a facial challenge only works if you can show that there's no set of circumstances under which it might be constitutional. And that analysis doesn't fit here.
I'm just trying to understand, in Heller itself, the U.S. Supreme Court only does what you ask, right? Which is just declare the statute unconstitutional.
Right.
They don't take the next step, which is shaping. I guess they can't, though, right? Yeah.
They remand it, and it's been the subject of further regulations, as has the city of Chicago after McDonald, dealing with how to regulate what the lawmakers of those jurisdictions believe rationally should be reasonable restrictions on various kinds of weapons. Back to your concern.
But I will add, because they are firearms, they were still under the restrictions of federal law, which prohibits felonies and domestic violence perpetrators and mentally ill to possess them. You wouldn't have that here.
Right, and I just don't think the sky will fall. You don't hear about, yes, of course there's the potential for misuse. That actually was the court's concern, the first time I argued this. Of course they can be misused. Of course some, sick individual could use a stun gun to torture. That's not how we decide whether a law is constitutional. You look at what it says, and you look at what the legislature has done, and you look at what the Supreme Court has said is permissible. And if that causes a problem for the legislature, I have no doubt that they will move expeditiously to take care of it. But in the meantime, people like Jamie Caetano, who could have been killed if she didn't have a stun gun, people like Brittany Rourke, who works every day in a dangerous job late at night in the combat zone and can't get I'm going outside the record here, but stun guns are, to Justice Kafker's point, uniquely suitable for those vulnerable individuals in the greatest need for armed self-defense. And that's also something that the court should consider.
But we don't grant that right of armed self-defense to those who've been previously convicted of a crime.
I'm not asking you to.
Well, the result of it is that those convicted of a crime will have the capacity to have weapons which, according to the statute, which is designed, quote, designed to incapacitate, temporarily injure, or kill. That's how the statute
But
defines.
the reality is, stun guns are designed not to kill. That is a unnecessary verbiage that, in reality, you cannot buy an electrical weapon. And I am going outside the record again. Perhaps you could alter one.
You can go on the internet and buy one of these things as easily. run a Google search, they're everywhere.
Right, but-
Whether it's legal to hold them, that's a whole separate matter, but they're readily purchasable.
They're purchasable, and I'm not sure that they're purchasable with a sufficient voltage to kill. You'd need to be an electrical engineer to refashion one. They manufacture them in order not to kill, which is why this whole notion about this is so dangerous is so ironic. Firearms, according to Justice Breyer's dissent in McDonald, are responsible for 60,000 deaths and injuries a year. Stun guns, 99.7% of the time, according to the data that's in the brief, cause no injury or virtually no injury, or no deaths and virtually no serious injury. So if you're looking about, what we have here as a society with the Second Amendment as it's been described by Heller, I would, for one, not be averse to a society where non-lethal weapons were more prevalent and lethal weapons were less prevalent.
Okay, thank you.
Good afternoon. May it please the court, Catherine Lear on behalf of the Commonwealth. Commonwealth respectfully requests the court affirm the denial of the motion to suppress and find that Chapter 140, Section 131J, constitutional. Stun guns and other electrical weapons are not protected arms under the Constitution, under the Second Amendment, because they are dangerous and unusual.
But they're less dangerous than regular guns. So that's complicated, right?
Well, Your Honor, I actually don't think it is complicated because handguns, yes, are protected under the Second Amendment and are conceivably more dangerous potentially than stun guns in some circumstances.
Well, and you shoot someone, most of the time, you're going to do lasting damage to them. If you hit them with a stun gun, unless they're have a heart condition or another rare person, they're not going to die generally. Actually, they're going to recover pretty quickly, fully, right?
Yes, but however, whether or not a weapon is not lethal or less lethal than a handgun is not the question under the Second Amendment. It's dangerous and unusual. And so while a weapon can be dangerous, if it's not unusual, then it's protected under the Second Amendment.
So what makes a weapon unusual?
Yes, Your Honor. So the Supreme Court in Heller, McDonald, and Catano did not really give us guidance on what's unusual, what's in common use. And the circuit courts have been divided on the statistics and the threshold of the statistics, but they have a consensus that it's an objective statistical inquiry.
Well, but if they've been banned here, they're unusual here. So there's no statistics we could look at for Massachusetts. Would we go to the rest of the country?
Your Honor, I think the correct inquiry would to look at the statistics nationally because we're looking at this under the Second Amendment and what the majority of the American public holds. And that's what, obviously, in the federal circuit courts, they're not just staying in the circuit either. They're looking at national statistics.
So, but what role then do those other 45 states that have permitted this, how do we factor that into the unusual analysis?
Sure, Your Honor. Well, I think the fact that there are 45 states that don't have a ban does not necessarily mean that that stun guns are usual. The fact that there's no ban in those states suggests possibly that stun guns are so unusual that the legislature didn't feel the need to adopt regulations for them. Now, some states, I think at the time IANA was decided in 2012, I believe there were 43 other jurisdictions that there were no bans. So we don't know, and IANA, I believe, implemented regulations after their decision. However, just because there's no ban in those states doesn't mean that they're common. And I think if you look at the statistics, which I think we have to go back to when we're grappling with this issue, is that Laser International, which accounts for 95% of all sales of electrical weapons, stun guns, tasers, stun guns have been available to the civilians since 1994, and their sales in 2010 were 6% of their sales went to civilians, and then 2014 went down to 2.3%. Yet 45 states, there's no ban.
But is that because there was an increase in what they were selling to law enforcement, so it changed the percentages?
Your Honor, I'm not entirely prepared to answer that question. I'm not sure, but I still think it's a significant decrease. And it's only a small percentage of their sales. And when you look at the whole whether you look at the whole number, there's only been 275,000 stun guns sold to civilians since 1994, which I think is the most relevant statistic. I believe that it's from a 2015 affidavit from a high-up person in Taser International. And if you think about that in relation to one stun gun, one person, that would only count for 0.08%, I believe, of the American populace owns a
How
stun
about
gun.
this on unusual? Obviously, we're not going to look at this through a contemporary lens. We understand that. But can we say, okay, if the Second Amendment is to protect, at least as far as Heller is concerned and McDonald, self-defense in the home, and if we're looking back at what the militia would be using, and if it would evolve into something technologically that we have a correlated back, then it would be protected, even if the innovation happened last year.
Correct.
But there's no connection between what the militia would be using and a stun gun now. Can we take that into account when we deal with unusual? I know we have to be careful about the contemporary lens issue.
Correct. I believe you can, and I believe it's a subsection of my argument in my brief about unusualness, about what is kind of the lineal descent argument. Everything that the Supreme Court and other courts have analyzed have been some type of lineal descendant of the same type of technology used from the muskets at the Revolution in the Common to now firearms, same type of technology, whereas a stun gun is completely different, the technology it uses, the type of effect it has. And I believe it's cited in my brief. I believe it's Parker. It's a D.C. Circuit Court opinion, which kind of made that analysis regarding.
But isn't that dangerously close to what we did before, where we were lectured by the U.S. Supreme Court not to do? Isn't the issue whether it's unusual in the sense of self-defense? Because, I mean, you know, a sawed-off shotgun is not a self-defense weapon. Neither is usually a machine gun. So this seems to be designed for self-defense, not to kill somebody. I mean, it can be misused, but its primary purpose seems to be self-defense.
And I understand. I do believe, and I agree that it does have possibly some utility in a self-defense context. However,
isn't that how it's being marketed? It's a way that you can defend yourself without permanently hurting someone else.
But the language under the Second Amendment case law is typically owned by law-abiding citizens for a lawful purpose. It's not typically owned. And I think, so we go back to the circular argument of the statistics and an objective statistical inquiry.
So, it can't be that we have to look to Cyber Monday sales and that if there was a huge leap in Cyber Monday sales, that which was not an arm last week now becomes an arm, can it?
I think it can be an evolving paradigm, and I think if you actually did look at the Cyber Monday sales, the sales were astronomical for the sale of firearms, which just goes to show you that handguns and firearms are the chosen weapon for self-defense in the United States and not tasers or electrical weapons.
Well, because of the
But I understand your question, Your Honor.
But if we want to minimize harm to people and still protect their rights to self-defense, are we going to really limit evolving technology? Because obviously you're going to have low sales on something that's a new invention. But if it may be a better invention and more protective and causing less harm, we want to discourage that?
I understand your concern, Your Honor, but respectfully, policy considerations and whether or not something that may be less lethal than a firearm should be.
It's not a policy question. It's what they mean by unusual. And they don't mean what this court said previously, that it's unusual in the sense that it wasn't like a musket. So that doesn't seem right to me. And then we're left with your statistics, which I think is a very fair reading of the U.S. Supreme Court, but I don't know if they really mean that, do they?
Well, absent guidance by the U.S. Supreme Court, this court is free to determine however they want to determine usualness within the confines of its precedent. I understand your concern that there could be an instance where we have new technology and something is going to be unusual because it's new and many people won't have it, but that's not the case here.
But the core principle the U.S. Supreme Court is trying to protect is self-defense, particularly self-defense in the home.
Correct, and if this court were to find that stun guns and electrical weapons are protected under the Second Amendment, which the Commonwealth does not concede, but if the court were to, I would agree that perhaps the statute is overbroad to the extent that it's a complete ban in the home, which is the core of the Second Amendment. I think the court should not strike down the rest of the statute banning people from carrying these dangerous weapons on the street, as that doesn't extend, as we discussed with my brother, that it doesn't extend to the public.
So say we do that. How would we do that without writing the statute? What are you suggesting we do? Because we don't get to rewrite the statute. So we would declare the statute constitutional in how? Tell me how you would do that.
I guess how I would possibly frame it, probably inarticulate at this point, that the statute is unconstitutional in so much as that it bans somebody from possessing a stun gun in the home, but not unconstitutional in possessing and carrying a stun gun in public.
I mean, we've saved many statutes, including the stalking statute, I believe, and other statutes by limiting its scope, in that case with regard to the First Amendment. So we do make it a practice to attempt to save statutes where we can. Is it your view that that's what we should do here?
Yes, in the event that you find that these are protected under the Second Amendment, then yes. I don't think Heller, my reading of Heller, is that it only goes so far as the complete ban of handguns in the home violated the Second Amendment, not the complete ban in public. And the Supreme Court, I don't think has ruled on that issue.
Has any court, has any circuit court, federal circuit court declared that there is a right to carry arms outside the home under the Second Amendment?
I don't believe so. I believe most circuit courts have they say that they are not going to decide that issue, and they just do the analysis, assuming that it does extend, and that's how they conduct the analysis. But I don't believe, of course I might be wrong, but I don't believe any circuit court has actually found that that right extends and gone beyond what the Supreme Court has ruled.
To do that right, we have to project how the U.S. Supreme Court's going to decide the right to carry question, right? The U.S. Supreme Court, what they did in Heller was say the ban is unconstitutional, right? Now, I understand that left in place federal statutes, but they didn't say the ban is constitutional so long as it's applied outside the home, right? They didn't do that. So we would have to, if we rewrite this that way, we would have to project what the U.S. Supreme Court's going to do in that case, correct?
I don't think that would necessarily be projecting what the Supreme Court's going to do. I think that, I'm sorry, I lost my train of thought on your.
Well, I mean, right now if we have a straightforward question, but the U.S. Supreme Court has not resolved the issue whether you can ban handguns or like weapons outside the home, right?
Correct, and I don't think that this court should extend Second Amendment protections where the court hasn't discussed them. That would be my answer to it. I don't think that would be projecting. If it's the Commonwealth's contention that they're not protected under the Second Amendment, and if the court has no further questions, the Commonwealth would be happy to rest on its brief.
All right, thank you.
Thank you.